whether that same evidence CDR are with the same case, same CDR આમાં હે સેમ છે અને અત્યારે આની અંદર જે સેમ છે પાઠ્યમાં સેમ છે ફૂલબર્કમાં સેમ છે આમાં સ્ટિંગ ઓપરેશન ટ્રાન્સક્રિપ્ટ તો મને સેમ દેખાય બધું છે સેમ એટલે તમે દલીલ નથી કરી સ્ટિંગ ઓપરેશન CDR માં તમારી કોઈ દલીલ નથી સિકેશ હા એટલે આશી સુધી દલીલ નથી કરી સવારે પૂછવા આવ્યા હતા ત્યારે મેં કીધું કે મેં 2 દિવસથી આપણે પરમ દિવસે CDR સ્ટિંગ ઓપરેશન આપવું જોયું ટ્રાન્સક્રિપ્ટ બંનેમાં સેમ છે કારણ કે આમના વોલ્યુમમાં ટ્રાન્સક્રિપ્ટ આખું ને આખું ટ્રાન્સક્રિપ્ટ મૂકેલું છે CDR તો સેમ જ કારણ કે લેડી એક છે મોબાઈલ એક છે એટલે ટાવર લોકેશનમાં તો કોઈ ફેરફાર આવે નહીં ના સેમ જ છે હા ગેડમ તપાસવાની નહીં એટલે બંનેમાં સેમ છે ને ત્રણમાં સેમ છે મારે પછી મારે કે બધા ત્રણ અને સ્ટિંગ બી સેમ છે ત્રણેમાં હા સ્ટિંગ ઓપરેશન છે ને એ પણ સેમ છે ટ્રાન્સક્રિપ્ટ આશીષ ખેતાન એક જ છે હા બરાબર બાબુ બજરંગી સાથેની જે આખી બધું ટ્રાન્સક્રિપ્ટ છે આખું જે સ્ટિંગ ઓપરેશન નું કારણ કે આમનામાં જે આખા વોલ્યુમમાં જે આખું સ્ટિંગ ઓપરેશન ના જે ટ્રાન્સક્રિપ્ટ અને જે બંને વચ્ચેનું કન્વર્સેશન છે એ તમારે એમાં રજૂ થયેલું આખું ને આખું એઝ ઇટ ઇઝ છે આમાં ખાલી ગામના આરોપી પૂરતું લીધું છે પેલામાં તો એક આરોપી પેલામાં ફરી પાછો આમાં એક બે કેસ એક જ ગુના સંદર્ભે 2 કેસ બાબુ તમને ખ્યાલ આવે પેલામાં હું શું કહું છું તમને ખ્યાલ આવે તમને ખ્યાલ આવે Actually same that is exactly and sir मैं आपने ये 837 in Pakia case in 857 in this case એના માટેના જે observations કોર્ટે કર્યા as to why the witnesses are not believed and the very set of witnesses show the presence of 837 in that case at one place, at B place, at C place, at D place at the same point of in the other side ડિફરન્સ આવે છે અને એ પણ કોર્ટે કન્સિડર કર્યું કે એ સમયે પાછું મને ગામમાં પણ બતાવ્યા અને કહ્યું કે એ જગ્યાએ બી જગ્યાએ સી જગ્યાએ એટલે તમારા કહેવા મુજબ કોન્સ્પિરસી 2 જગ્યાએ થઈ પાટિયામાં અને ગામમાં બટ કોન્સ્પિરસી ઇઝ એ કહે છે કે એક જ ગુના એક જ ટ્રાન્સક્રિપ્ટમાં 2 ગુના દાખલ થયા એટલે આ ટ્રાન્સક્રિપ્ટ ત્રણે ગુનાના કામે કબજે લીધી ગુલમર્ગ આમાંના કબજે લેવાની વાત નથી ગુનો દાખલ થવાની વાત ચાલે છે કબજે તો તમે લઈને કર્યું છે એની કોઈ વાત નથી દાખલ થયાની વાત હા દાખલ બે થયા એક નરોડા ગામનો નંબર સાહેબ પૂછે ટ્રાન્સક્રિપ્ટ એક જ આ ટ્રાન્સક્રિપ્ટ એક અને એના આધારે 2 ગુના દાખલ થયા એક જ ટ્રાન્સક્રિપ્ટ અને એક જ કન્વર્સેશન ઉપર અલગ અલગ 3 ગુનાઓ હા આપણે મારી પાસે તો 2 અત્યારે કમ્પેરિઝન 2 ની ચાલે છે ઓ રેશના written arguments તો અંદરથી લે written arguments લાવ એનું અંદર પડ્યું છે ચાલ આના in reference માં in furtherance to this submissions which we have made તો હું આપને વોલ્યુમ નંબર 10 માંથી જે જજમેન્ટના વોલ્યુમ નંબર 10 લાસ્ટ વોલ્યુમ નંબર 10 આખા વોલ્યુમ 1 page number 3139 answer apa page 3139 sir ત્રણ પેરેગ્રાફ મારે વાંચવા છે 3139 તો પેરેગ્રાફ 418 નંબર અને સર જે પ્રિન્સિપલ કાયદાના છે એના આધારે કોર્ટે શું કારણ કાઢ્યું that I just wanted to point out આવા ત્રણેક જગ્યાએ જે પ્રિન્સિપલ ડિવિઝન બેન્ચ છે જે એનન્શિએટ કર્યા which will be very relevant which will be very germane to the set of facts of this case also એ તમારે સર આપને બતાવો this is a part of the discussion in the conspiracy head પણ એની નીચે સાહેબ આપણે વાંચેલું છે પણ for my satisfaction only 3 paragraphs આવી જાય 419 થી સાહેબ વાંચ્યા 418 ને કહ્યું the evidence on record is required to be evaluated in the light of the above principles 419 considering the evidence adduced by the prosecution if one considers the testimonies of the above for 11 witnesses, witness, all that they have mentioned is the presence and participation of the accused. From the testimonies of none of the witnesses can one discern any meeting of minds among the accused for premeditation and pre-concert. Apart from the fact that this kind of evidence has come on record after a considerable period of 6 years, even assuming after 6 years, even assuming that the versions given by the witnesses are true and correct, all that it shows is that the accused were part of the mob and were leading the mob. One of the witnesses has referred to sports having been brought in a vehicle and having been distributed at the instance of accused number 37, same accused in this case, which part of the evidence has not been accepted by the trial court on the ground that it was not possible for the accused to have distributed sports in this manner in the gaze of the public. From the circumstances referred to by the witnesses in their testimony, there is nothing to infer a meeting of mind among any of the accused or any pre-planning, as rightly submitted by the learned counsel for the appellants, in view of the incident of burning a coach of Mudra that had taken place on the previous day. There were incidents of rioting all over Gujarat, and the public had come out spontaneously to ventilate their anger. Therefore, insofar as the accused persons, other than those on whom the sting operation was conducted and served, the chain of circumstances has not been established to prove that there was a meeting of minds between the accused and that they had planned in advance to commit any illegal act. Two more collections. Now, this is in specific reference to the present applicant Maya. Insofar as accused number 37 is concerned, even if the evidence of the witnesses is taken on its face value, at present, her presence at the scene of offence can be said to have been established, and she can be stated to have instigated the accused in the commission of the offence. From no part of the evidence of the witnesses can it be called out that there was any meeting of mind between accused number 37 and any other co-accused. Insofar as the presence of accused number 37 at the scene of offence is concerned, all the 11 witnesses have given different versions showing her presence at different spots at more or less the same spot. PW 104 says that after 9 to 9:30, first the police jeep came near the workshop gate, followed by Kishan Purani, Manoj Pitiovala, and Bhumi Singh. And after a while, white Maruti car came in which he saw MLA Mayaveli. She spoke to the about the accused and the police in an aggressive tone, and all of them gestured to the mob, which had run away, and called the mob back. Even after which Mayaveli spoke to the mob in an aggressive tone and went back to the same car that she had come. Whereas 2, PW 136 speaks about Mayaveli coming in a white car near a police vehicle. It was parked near a ST workshop and talking to the police, after which the police fired at the Muslim. 3. 176 at the end of her examination in chief has stated that in the mob which she saw between 9 to 9:45, she had seen Mayaveli all night. Nothing has been stated about the place where she saw her, nor has any role been attributed to her. PW 149 deposed that at around 9 to 9:30, she was standing next to the ST workshop compound wall, and Maisulwala was also present at the ST workshop in the government jeep. At this time, Mayaveli came out of the mob, went near Maisulwala, and spoke to him. She has also referred to the presence of several accused in the mob. She has stated that after talking with Maisulwala, Mayaveli left, after which there was police and private firing. The witness does not describe the manner in which Mayaveli left. PW 192 has reported that she has seen Mayaveli in the mob, which has come from the direction of the crowd. In this mob, she has also seen Manoj Vidiyowala, Vipin Uttowala, Santosh Dudwala, Guttu, Naresh, Suresh Langraj, younger brother, etc. Mayaveli was instigating the public by saying, "Come forward and kill." Then 6, PW 198 says that mobs had gathered near the ST workshop as well as the Sakikwat gate. And in the mob, we can see Mayaveli, Babu Bajrangi, Sachin, Mukti, Ashok, so Manoj, Suresh, Haresh, Vipin, at around 9:30 in the morning. Then said PW 236. So reports that at around 8:30 to 9 in the morning, he went near Metraj Hotel where there was a mob of 5 to 10,000 people. While he was present there, Mayabin came in a Maruti car together with the PAs. Mayabin gave a provocative speech to the people there and instigated them to either head down the so and so. After giving a speech in it, after Mayabin left, the public was incited and advanced towards the Muslim area. This witnesses report that at around 11 o'clock, Mayabin came in a white color Maruti car near the ST workshop. It was followed by a dressed. Mayabin alighted from the car and gestured to the mob standing near the car, whereupon about 100 leaders came, including Mayabin's PA. She talked to them and thereafter, under her instructions, her PA distributed weapons from the chief to the leaders. Thereafter, Mayabin left. The people in the mob, including her PA, attacked the ministry. Then, 8. PW 156 says the mob. Then mob started coming at 9 a.m. Two police vehicles came near the ST workshop and unloaded 2 blank trunks. Thereafter, a white car arrived and Mayabin alighted from the car and said, Maro Sala. Thereafter, the mob attacked. Then 9. PW 227 has report that at around 9 to 9:15 in the morning, the mobs had started coming from the side of Pankaj Hotel as well as Krishna. In the mob from side of Krishnanagar, he had seen VP, Guddu, and Babu, armed with weapons. In the mob from the side of Nankar, he had seen Mayabin on the road and she was telling the people in the mob to march ahead and that she was also with them. Then 10. PW 52 has stated that from the meets of the mob, a white car came from the direction of Natraj Hotel and halted near the masjid, and Mayabin and her assistant alighted from the car. Mayabin started talking with the people in the mob. Mayabin told the mob that the masjid and Muslim area should be destroyed. The witness also claims to have seen something like a pistol in Mayabin's hand, with which she was firing, and after firing, Mayabin told the mob that they should continue, and thereafter she returned in the same car in which she had come. And the last witness, 11, PW 143 has deposed that he was standing near his Aishar vehicle near Panchwati estate when Mysorewala came and parked his jeep there, and together with him 4 to 5 policemen also alighted from the jeep. After 10 minutes, a white Maruti car came from which their MLA Mayabin, Bipin, Murli and Guddu alighted, and the mob followed the car. Thereafter, weapons were distributed from the car and Bipin saw the witness and chased him away. Now the last paragraph, 421. Thus, 11 witnesses have testified regarding having seen Mayabin Kodnani at the scene of offense in the morning on the day of the incident. The credibility of the witnesses and the veracity of the versions given by them has already been discussed here in above. However, assuming for the sake of argument that all the witnesses are speaking the truth, it may be noted that out of the 11 witnesses, 6 witnesses claim to have seen her alighting from a white colored Maruti Fronti car, while PW 104, 136, 156 refer to only Mayabin alighting from the car. PW 236 and 52 speak of her alighting from the car with her PA assistant, whereas 143 talks of Mayabin, Bipin, Murli and Guddu alighting from the car. The time referred to by all these witnesses is more or less the same, that is around 9 to 9:30 in the morning. 236, however, claims to have seen accused number 37 twice, one at around 9 to 9:30 and again at around 11 a.m. The remaining 5 witnesses, that is 176, 149, 192, 198 and 227, claim to have seen Mayabin in the mob. All these witnesses also claim to have seen her at around the same time. Again, while PWs 1, 2 and 3 say that Mayabin spoke to the police, PW 104 also says she spoke to the mob. 176 only refers to the presence of Mayabin in the mob. 192 says she saw Mayabin with several other accused and Mayabin was instigating the mob, while 198 simply refers to the presence of Mayabin with several other co-accused in the mob, and 227 says he saw Mayabin in the mob and that she was instigating the mob. Thus, while some of the witnesses say Mayabin came in a car and then either spoke to the police or instigated the mob or did both and left, while others speak about her mere presence in the mob, or of her presence in the mob and instigating the mob. Now kindly see this. Considering the overall evidence which has come on record, it is difficult to reconcile the versions given by the different witnesses in as much as if around the same time Mayaben came in a car and left, how could she be present in the mob? Besides, around the same time, how is it possible that Mayaben came in a car alone, or came with her PA, or came with Bipin, Murli and Guddu in a car? The trial court has simpliciter accepted the testimonies of all the witnesses, brushing aside all the discrepancies in their evidence and without considering the creditworthiness of such witnesses. Since the prosecution has put forth evidence of witness which conflict with each other, and it is not possible to reconcile the same, the benefit of doubt has to go to the accused. Another notable aspect of the matter is that while the above referred witnesses spoke to Mayaben, coming in a white Maruti Fronti car, none of the witnesses have given the number of the vehicle. Not only that, no investigation has been carried out by the SIT to ascertain whether accused number 37 owned or was using any such vehicle at the relevant time, nor has it attempted to trace out such vehicle. This is a serious lacuna in the investigation by the SIT, because all evidence against accused number 37 Mayaben has come only at the stage when the SIT came into the picture. સાહેબ અહીંયા પણ એવું જ છે, ક્યાં તો સ્ટેટમેન્ટ લેવાયા નથી અને જેમના સ્ટેટમેન્ટ લીધા છે એમણે નામ આપ્યું નથી. For the first time SIT પાસે આ 14 જણ આવે છે અને કહે છે કે માયાબેનને સાહેબ again time, if the honorable court sees the timing in Narora Patia, it is already discussed and now the finding of fact has come on record. સાહેબ સેમ ટાઈમે પાછા ગામમાં પણ છે, સેમ ટાઈમે વિધાનસભાથી નીકળીને સોલા હોસ્પિટલ પર છે, according to the government officials, according to the defense witnesses also, they are found present at civil hospital. Then she has proceeded to RTO. Then after 11:30 she has gone to civil hospital, thereafter her own hospital, again coming back to the hospital. Where is the question of she remaining present everywhere? She is not a superpower, and cold details would play a very prominent role at this stage, which is a documentary evidence submitted by the prosecution and relied upon it. Exhibit 1101. Sir, we have prepared a small chart. This is only just with a view to give a broader idea. We'll give a copy to the other side. The fact about the timing and the place, witness wise, is admitted according to us. If any discrepancy is found, the prosecution may point out. સાહેબ આપ ઉપરથી જોશો તો 8:30, 8:30 થી 9, 9 થી 9:30, 9:30 થી 10, 10 થી 10:30 થી છેક 1:30 થી 2 વાગ્યા સુધીનો આખો ટાઈમ સ્લોટ અમે બતાવેલો છે, અડધી કલાક. અને સાહેબ વિટનેસીસ જે છે, પ્રોસિક્યુશનના વિટનેસીસ 14, 20 થી 149. સાહેબ એ ક્યાં બતાવે છે તો કે 9 થી 9:30 નરોડા ભાગોળ કોઈ બતાવે છે, એક મણિકાકાની શોપે બતાવે છે, એક મુખી પાન પાર્લર બતાવે છે અને એક નરોડા પોલીસ સ્ટેશન બતાવે છે. બીજા વિટનેસ છે 9:30 થી 10 ની વચ્ચે નરોડા ભાગોળ બતાવે છે. એક વિટનેસ 10 થી 10:30 મ્યુનિસિપલ ઓફિસ બતાવે છે. બીજા વિટનેસ પોસ્ટ ઓફિસે બતાવે છે અને ત્રીજા નરોડા ભાગોળે બતાવે છે. 10:30 થી 11 ની વચ્ચે એક વિટનેસ પંચાયત ઓફિસે બતાવે છે. એક એમ કે છે કે ગેલેક્સી સિનેમા તરફથી આવતા હતા આ સમયે, એક કે છે કે મ્યુનિસિપલ ઓફિસની સામે ઊભા હતા અને એક કે છે પંચાયત ઓફિસ પાસે હતા, એટસેટ્રા. હવે સાહેબ અહીંયા બધા મોટાભાગના વિટનેસ અહીંયા પૂરા થઈ ગયા 11 પહેલા. એક જ વિટનેસ એવા છે કે જે 148 જે નરોડા પાટિયાથી આવે છે 12:30 થી 1 ની વચ્ચે એવું બતાવે છે. હવે સાહેબ આને ને આને આપણે ગવર્મેન્ટના વિટનેસીસને લઈએ તો 135 સાહેબ મારી હાજરી 10:30 થી 11 ની વચ્ચે સોલા સિવિલ હોસ્પિટલ બતાવે છે. 139 10 થી 10:30 ની વચ્ચે મારી હાજરી સોલા સિવિલ હોસ્પિટલ બતાવે છે. 140 છે અગેન 10:30 થી 11 ની વચ્ચે સોલા સિવિલ હોસ્પિટલ બતાવે છે. અને 187 ઇન્વેસ્ટિગેટિંગ ઓફિસર ઓફ SIT એ કહે છે કે સાહેબ 8:30 થી 9 માં વિધાનસભા, 9 થી 9:30 વિધાનસભા, ત્યારથી નીકળીને સોલા સિવિલ હોસ્પિટલ, 10 થી 10:30 સોલા સિવિલ હોસ્પિટલ, 10:30 થી 11 સોલા સિવિલ હોસ્પિટલ અને 11 થી 11:30 સોલા સિવિલ હોસ્પિટલ. ત્યાર પછી 11:30 થી 12 અસારવા સિવિલ હોસ્પિટલ, 12 થી 12:30 અસારવા સિવિલ હોસ્પિટલ અને 12:30 થી 1
Asarwa Civil Hospital, which is the admission on the part of Mr. Mal, who happens to be the investigating officer of the SIT, which I have read yesterday. બધા admission સાહેબ મેં આ કુલ જે 26 પાના વાંચ્યા એની deposition માંથી, where he has admitted these facts on record. હવે સાહેબ મારા ડિફેન્સ વિટનેસીસ જુઓ તો ડિફેન્સ વિટનેસીસમાં 45 છે અસારવા સિવિલ હોસ્પિટલ 12:30 થી 1 બતાવે છે, 46 છે મારી હાજરી 10 થી 10:30 માં 16 સિવિલ બતાવે છે, 47 છે વિધાનસભા સવારના ભાગે અને પછી અસારવા સિવિલ હોસ્પિટલ બતાવે છે, ઇઝ ઓલ્સો એન MLA. પછી 48 એ સાહેબ 10 થી 10:30 અને 10:30 થી 11 16 સિવિલ બતાવે છે, 49 છે સવારના 9:30 થી 10 16, 50 છે 16 સાહેબ એટલે સવારે 9:30 થી માંડીને છેક 11:30 સુધી 16 અને પછી અસારવા સિવિલ હોસ્પિટલ. 51 સેમ પછી અસારવા સિવિલ હોસ્પિટલ. 52 છે સાહેબ એ મારી હાજરી 1 થી 1.5 ની વચ્ચે શિવમ મેટર્નિટી નરોડા બતાવે છે અને 53 છે એ 1.5 થી 2 ની વચ્ચે શિવમ મેટર્નિટી હોસ્પિટલ નરોડા બતાવે છે અને 58 છે સાહેબ અગેન સવારના વિધાનસભા અને 9:30 થી 16 તો છેક 11:30 વાગ્યા સુધી. હવે સાહેબ CDR ટાવર જુઓ, exhibit 1101 which you have mentioned with the yellow marking. It is an admitted document relied upon by the prosecution. Kindly see મારું ટાવર લોકેશન ગોતા ચોકડી 9:30 થી 10 એટલે 16, અગેન ગોતા ચોકડી 10 થી 10:30 એટલે 16, ગોતા ચોકડી 10:30 to 11 એટલે 16 હોસ્પિટલ, અગેન 11 થી 11:30 ગોતા ચોકડી 16. હવે સાહેબ આ તો 11:30 સુધી ગોતા ચોકડીનું મારું લોકેશન હોય એનો મતલબ મારો ફોન બીજા કોઈ પાસે હતો, બીજા કોઈ વાપર્યો છે, હું કોકનો બીજાનો ફોન વાપરતી હતી, એવું તો કંઈ પુરાવો જ નથી. મારો ફોન મારી પાસેથી મળ્યો, મારા ફોનનું જે લોકોએ ડિટેલિંગ કરાવ્યું છે એના કોલ રેકોર્ડ કઢાવ્યા છે, કોલ ડેટા કઢાવ્યા છે અને જે રિલાય કરે છે એના ઉપર પ્રોસિક્યુશન. પછી સાહેબ જુઓ મારું 11:30 થી 12 શાહીબાગ, 12 થી 12:30 સાબરમતી અને 12:30 પછી નરોડા નારોલ હાઈવે જ્યાં મારું હોસ્પિટલ છે સેજપુર બોગામ શિવમ મેટર. તો ધીસ કોલ ડિટેલ્સ ઓલ્સો ઇન્ડિકેટ. હવે સાહેબ હું કેટલી જગ્યાએ હાજર રહું, મારું આ જો આ ઓલ ગવર્મેન્ટ વિટનેસીસ, my defense witnesses and the call details submitted and produced by the prosecution, where they want the court to believe that CDR. એ લોકો જ કહે છે કે સાહેબ આ માનો અમે એના ઉપર રિલાય કરીએ છીએ. Now if all the 3 set of circumstances show my presence somewhere else than Naroda Gam, then where is the question of I being present at either Naroda Gam or Naroda Patia? As far as Naroda Patia is concerned, 11 witness મારી વિરુદ્ધમાં સાહેબ જુબાની for the first time સ્ટેટમેન્ટ આપીને આપી 6.5 વર્ષ પછી કોર્ટે બધી ડિસબિલીવ કરી. Same is the position here. All 14 witnesses show my presence between 9 to 11 at Naroda Gam. જ્યારે મારી હાજરી એ સમય દરમિયાન એડમિટેડલી 16 છે. This sir, there cannot be a worst case than the case of such a nature where the witnesses have been instigated or have been asked to give wrong statements, false statements before the SIT after 6 years, and they had a courage to say such a false story on oath before the court. What action could be taken against such witnesses? I am just putting a question to myself. An innocent lady, an MLA, a representative of the people, even if she talks to somebody or somebody calling her, it is not unnatural. Fortunately, સાહેબ આ ફોન અને સાહેબ 2 કલાકના હું આપને કહું, આ તો સાહેબ હવે એ સ્ટેજ નથી અત્યારે, પણ મારું 8 થી 10 ની વચ્ચેના લોકેશન ડેલિબરેટલી એ લોકોએ સપ્રેસ કર્યા અને હાઈકોર્ટમાં એફિડેવિટ કરી to support an application for cancellation of my bail in Naroda Patia case. Rather this case, આ જ કેસ બંનેનું ભેગું હતું. And Mal has admitted કે આવી એફિડેવિટ ત્યાં કરી, એ જે ત્યાં જે બતાવેલું છે ને એ ખરેખર એવું નથી. બે પત્રક બંને પત્રક સાહેબ જે પત્રક ત્યાં રજૂ કર્યું એ બી અલગ અને રેકોર્ડ ઉપર આવ્યો એ બી અલગ. કોલ ડિટેલ CDR સાહેબ મળે ટેલિફોન ડિપાર્ટમેન્ટમાંથી તો 2 કલાકના કોલ રેકોર્ડ ના મળે એવું તો બને જ નહીં. અને એ દરમિયાનમાં 3 કોલ આવ્યા છે મને. from the people, from the public at large. અને એ 3 કોલમાં પણ મારું લોકેશન છે વિધાનસભાથી સિવિલ હોસ્પિટલ સોલા સિવિલની વચ્ચેનું બતાવે છે. Why should that be suppressed? Are the officers, are the witnesses here to harass somebody, to implicate somebody falsely? In a democratic country like ours, this is a very serious attempt. The people has to be taken to task. This is only for the convenience of the court. The time and the fact which is mentioned, let it be controverted by the prosecution. If it is not to be controverted, then this has to be considered as the truth which has come on record. So this is about that conspiracy part where the Honorable Division Bench of the High Court has also considered કે નરોડા પાટિયા કેસની અંદર પણ સાક્ષીઓ એકબીજાની કોન્ટ્રાડિક્ટરી જુબાની આપે છે, ટાઈમ માટે કોન્ટ્રાડિક્ટરી જુબાની આપે છે, પ્લેસ માટે કોન્ટ્રાડિક્ટરી જુબાની આપે છે. હવે સાહેબ એ જ ટાઈમે હું પાછી નરોડા ગામમાં છું, એ જ ટાઈમે હું સોલા હોસ્પિટલ છું. As I have stated, I am not a superpower who can be said to be omnipresent everywhere. અને 6 વર્ષ પછી સાહેબ સ્ટેટમેન્ટ આપી અને કોઈને ઇમ્પ્લિકેટ કરવા, this is a very serious attempt made by the prosecution in my humble submission. સાહેબ એક આ પ્રિન્સિપલ હતો. બીજો એક પ્રિન્સિપલ છે, ફર્સ્ટ વોલ્યુમ આપશો, ફર્સ્ટ વોલ્યુમ જજમેન્ટનું ફર્સ્ટ. સાહેબ આના ફર્ધરન્સમાં જ્યારે ગુજરાત હાઈકોર્ટે કહ્યું ડિવિઝન બેન્ચે નરોડા પાટિયામાં કે આ 6 વર્ષ પછી જે ફોર ધ ફર્સ્ટ ટાઈમ સીટમાં સ્ટેટમેન્ટ આપ્યા છે, those witnesses are not prima facie believable. અને જેમને બિલકુલ સ્ટેટમેન્ટ આપ્યા જ નથી, આપ્યા છે શરૂઆતમાં પોલીસને અને એમાં નામ નથી બતાવ્યા અને પછી ઇમ્પ્રુવમેન્ટ કરીને એસઆઈટીમાં નામ નાખ્યા છે, there also the witnesses are not believed. સાહેબ એના માટે હું 2 સેમ્પલ વિટનેસ છે આપને ખાલી એનું એનાલિસિસ બતાવવા માંગુ છું. સેમ્પલ વિટનેસ નરોડા પાટિયા કેસમાં. If the honorable court comes to page 150, એમાં સાહેબ 28.3 in the middle. In rejoinder, Mr. So-and-so submitted that the delay in disclosing the facts by the witnesses is one of the most relevant facts which needs to be explained by cogent evidence. If important, material, vital, and relevant facts about the incident or accused are coming on record firstly after more than 2 months or so, and subsequently after a period of more than 6.5 years, there has to come on record some reason, explanation, more so a cogent and convincing, logical and acceptable reason and explanation, which is completely lacking in the present case. It was urged that such unreasonable delay in disclosing facts or names of the accused ultimately does affect the very credibility of a witness and thus adversely affects the quality of evidence of such witness. The very requirement of a witness being of a sterling quality is lost the moment the consistency is lost. હવે સાહેબ આના રેફરન્સમાં આપ ફર્ધર જોશો. I'll straight take the honorable court to para 28.5 on page 153. After discussing the law, the court said thus, am I with the honorable court? Thus the Supreme Court had endorsed the view that where the city was in turmoil, the persons having witnessed crimes would naturally be apprehensive and afraid in coming forward to depose against the perpetrators till things settled down, that the state machinery was overworked. And in such circumstances, delay in recording the statements of witnesses cannot be a ground to reduce its evidentiary value or to completely ignore it. This decision would be squarely applicable to the facts of the present case insofar as the statements recorded by the first investigating agency are concerned. એટલે સાહેબ ડિવિઝન બેન્ચે એમ કહ્યું કે ભાઈ આટલા સિરિયસ મેગ્નિટ્યુડનો ક્રાઇમ બન્યો હોય ત્યારે વિટનેસીસ થોડા મોડા પોલીસ પાસે જાય અથવા તો મોડા સ્ટેટમેન્ટ રેકોર્ડ થાય 1 or 2 મહિના, તો એમાં કંઈ there is nothing wrong. Because the Supreme Court has also in such given cases had held કે ભાઈ આવા delayed statement છે તો એ delay કરીને એને ignore ના કરી શકાય. Therefore, the first investigating agency recording of these statements by that agency, which were ignored and completely bypassed by the trial court in Naroda Patia case, is reversed by the Honorable High Court. કારણ કે નરોડા પાટિયા કેસમાં ટ્રાયલ કોર્ટે પોલીસ સ્ટેટમેન્ટ સાહેબ કન્સિડર જ નહોતા કર્યા અને એમ કહ્યું કે જે એસઆઈટીમાં 6 વર્ષ પછી કહ્યું એ જ સાચું અને એના આધારે જે ડિપોઝિશન આપી એના આધારે સજા કરી. જ્યારે હાઈકોર્ટે એમ કહ્યું કે ભાઈ ભલે ડિલેટ સ્ટેટમેન્ટ છે, ભલે મહિના 2 મહિના પછી આપ્યા છે, 5 દિવસ પછી આપ્યા છે કે 15 દિવસ પછી આપ્યા છે, બટ ઇન a given set of facts those statements could not be ignored. અને એટલા માટે કન્સિસ્ટન્સી એ રીતની જોઈએ કે પોલીસ સ્ટેટમેન્ટ પણ માનવા જોઈએ, એસઆઈટીના સ્ટેટમેન્ટ પણ જોવા જોઈએ અને કોર્ટ સમક્ષની જુબાની પણ જોવી જોઈએ. અને એમાં જો કન્સિસ્ટન્સી આવતી હોય then only રિલાયબલ અને ક્રેડિટ વર્ધી વિટનેસ હોય તો પર્ટિક્યુલર આરોપી સામે એનો પુરાવો વાપરી શકાય. Then kindly see next page, page 154, para 28.6. Thus, whether or not the delay in recording statements of eyewitnesses has affected the credibility of the prosecution is a matter on which no straitjacket formula can be evolved, nor any thumb rule prescribed for universal application. The aspect regarding delay in recording statements of the witnesses has to be considered in the background of the facts and circumstances of the case. Whether city was in turmoil and the persons who have witnessed the crimes were naturally apprehensive and afraid in coming forward to depose against the perpetrators till things settled down and the state machinery was overworked. Delay in recording the statements of witnesses cannot be a ground to reduce its evidentiary value or to completely ignore it. That is said in so far as the police statements are concerned. હવે સાહેબ 28.7. According to the learned special PP, the main reason as to why the statements made by the witnesses before SIT should be accepted despite a delay of more than 6.5 years is that the SIT had conducted the investigation pursuant to the directions of the Supreme Court. In this regard, it may be noted that a copy of the petition filed before the Supreme Court has not been placed on the record of this court. Therefore, this court does not have the benefit of presuming the contents thereof. Insofar as the order of the Supreme Court directing constitution of a special investigation team is concerned, the same is based on a consensus and therefore no reasons have been assigned for directing further investigation in the case. There is no comment on the previous investigation carried out by the police as to whether the same is deficient or unreliable. It cannot be gainsaid that if the Supreme Court was of the opinion that the previous investigation should be vitiated, it would have directed re-investigation and not further investigation. Moreover, the very expression further investigation indicates investigation in furtherance of the investigation carried out earlier. Therefore, the question of discarding the previous statements recorded by the police or giving lesser weightage to the same does not arise. Needless to state that it is settled legal position that the version given by a witness at the first point of time is of utmost significance. Subsequent statements may be given based on tutoring, deliberations, etc., which is normally absent in the first statement, which normally is recorded immediately after the incident. Then 28.8. On behalf of the prosecution, it has been pointed out, the witness after witness has stated that though they had named the accused, the police had not written them down, and therefore when the witness has named the accused for the first time before SIT, and then in his or her deposition and her identified them, such evidence deserves to be accepted. જો સાહેબ આ એમની દલીલ હતી કે પોલીસમાં ભલે નામ ના આપ્યું હોય, ફર્સ્ટ ટાઈમ સીટમાં આપ્યું હોય, પછી કોર્ટમાં આપ્યું હોય ને આઈડેન્ટિફાઈ કર્યા હોય તો એમને માનવા જોઈએ. In this regard, it may be noted that the accused whom the witnesses have named, except for accused number 37 Mayaben and a few others, like accused number 52 Sachin Modi, have been named by certain witnesses in their statements recorded by the police. In fact, the police witnesses have also named certain accused persons. Now, in the case of these very accused whose names have been recorded by the police, in the case of some witnesses, it is the case of other witnesses that the police were not recording the names of such accused. When the names of certain accused have been recorded by the police, it is difficult to believe that in case of other witnesses, the names of those accused would not be recorded. Now, kindly see the finding in 28.9. In the opinion of this court, the submission that as the statements have been recorded by the investigating officer sit, in view of the further directions issued by the Supreme Court, the same should be given more weightage. આવી રજૂઆત કરી સાહેબ અને કોર્ટે ના પાડી કે that submission does not merit acceptance. Inasmuch as further investigation in the ordinary course or pursuit to directions issued by the Supreme Court still amounts to further investigation under section 173 subsection 8 of the code. In case of any witness whose statement has been recorded by the seat after a period of more than 6 years of the incident, such delay has to be explained. When a witness names certain accused before the police and subsequently names some other accused before the SIT, some plausible explanation has to come forth as to why such names were not given first in point of time, and not a stock statement that they were giving the names, but the police were not recording the same. Notably, most of the witnesses have claimed that the contents of their police statements were not read over to them, and therefore they had no reason to believe that the police had not recorded the names of the accused as stated by them. So this is about the opinion of the court that if the names are given only in the SIT, not given before the police, and thereafter before the court and identification, prosecution said that they should be believed. The High Court said they can't be believed. A witness, if is found on its overall testimony to be completely reliable, truthful, and trustworthiness, and further, એટલે સાહેબ પહેલા તો એક વિટનેસ એકદમ રિલાયબલ દેખાવો જોઈએ, અને હાઈકોર્ટ એમ કહ્યું કે if the witness is held to be so reliable, then the question of consistency, consideration of consistency would arise. પછી એ જોવાય કે સાહેબ એને પોલીસમાં પણ નામ આપ્યું છે, એને SITમાં પણ નામ આપ્યું છે, કોર્ટમાં પણ નામ આપ્યું છે, અને આઈડેન્ટિટી. Then only that witness is found to be of sterling quality, not otherwise. એટલે સાહેબ હું આપને જે પેલા બે દાખલા જે બતાવવા માંગુ છું ને, બે વિટનેસના, they are witness number 37 and 52 in that Naroda Patia case, and that the honorable court would find them on page 421. I'm sorry, 393. Analysis is on 421.
399.
393. મને લાગે એના પછીના વોલ્યુમમાં હશે. નેક્સ્ટ
392 સુધી.
સેકન્ડ વોલ્યુમ આપો.
Second volume of
સાહેબ ઘણું બધું એનો ફેક્ટ્સ ઉપરનું ડિસ્કશન છે, એટલે હું આપને સ્ટ્રેટ એનું એનાલિસિસ જે છે ને એના ઉપર હું લઈ જઈશ. આપને બે જ વિટનેસ મારે બતાવવા છે. PW37 એનું એનાલિસિસ છે પેજ 421, પેરેગ્રાફ 55.46. કુલ 46 પેરેગ્રાફ ડિવોટ કર્યા છે કોર્ટે એને ફેક્ટ્સ ઉપર ડિસ્કસ કરવા માટે. પણ એનાલિસિસ શું છે સાહેબ હું આપને બતાવું. ફ્રોમ ધ ટેસ્ટિમની ઓફ ધીસ વિટનેસ, it emerges that his first statement was recorded by the police on 11/4/2002. આપણા કેસની જેવું છે, કાં તો એપ્રિલ, મે અથવા જૂન 2002 માં જે શરૂઆતમાં લેવાયા છે, wherein he has not named any accused. It also appears that he had stated that his son was killed in the morning by a mob which came from the side of the canal, assuming that there may be a mistake in mentioning the time. One striking fact which emerges is that he had not named any accused in his statement recorded by the police. Of course, it is the case of the witness that he had named the accused, but the police had not recorded the same. It appears that another statement of this witness was recorded on 25/6/2002, which was more or less in the nature of a loss damage analysis statement. Even at this stage, the witness has not named any accused in his statement. And for the first time that he has named the accused before the SIT. While the witness has lodged a complaint in connection with the loss and damage caused to his properties in the incident, he has not lodged any complaint regarding the death of his son. In his cross-examination, it has been elicited that after they received compensation for the death of his son, they had remained silent, and it was only when the SIT was constituted that he had come forth to get his statement recorded and had named 6 accused referred to in his examination in chief. While it is true that considering the conduct of the police at the time of the incident, the witnesses would suffer from lack of faith insofar as the police authorities are concerned. However, even when the statement was recorded, he has not named any accused, and the version of the incident stated before the police does not tally with the version stated before the court. હવે સાહેબ આનું કન્ક્લુઝન જુઓ. This witness therefore does not appear to be a credible witness and no part of his evidence can be relied upon. એટલે સાહેબ આ એક સેટ ઓફ સ્ટેટમેન્ટ થયું કે જેમણે પોલીસ સ્ટેટમેન્ટ આપ્યા છે પણ નામ નથી આપ્યા અને ફોર ધ ફર્સ્ટ ટાઈમ એસઆઈટી માં આપ્યા છે. all those witnesses, હું આ સાહેબ સેમ્પલ જ વાંચું છું, my statement may be taken from record, that all those witnesses 327 witness સાહેબ એમાં એક્ઝામિન થયા છે. all those witnesses whose statements are recorded by the police, but for a particular accused, if the name is not given and given for the first time before sit, witness is not believed and witness is not considered as truthful and reliable witness. So this is one. અને સાહેબ એના પછીનું 52 અમીનાબેન બેલી, એનું એનાલિસિસ સાહેબ સીધું આપ જુઓ પેજ 454. તો પેલા વિટનેસમાં સ્ટેટમેન્ટ છે, નામ નથી અને એસઆઈટીમાં ફર્સ્ટ ટાઈમ આપ્યું. આ વિટનેસ એવું છે સાહેબ એનું સ્ટેટમેન્ટ જ નથી પોલીસ. For the first time straight, first statement is recorded before SIT. Kindly see analysis. From the testimony of this witness, it emerges that the statement was not recorded by the police at the 11th time in the year 2002. After the riots, the witness appears to have shifted to Maharashtra. And it was only 6 years after the incident that the witness traveled from Bhiwandi in Maharashtra to Ahmedabad for giving a statement before the SIT. As to how she came to know that a statement is required to be recorded is also not very clear. In her testimony, the witness has referred to various incidents which do not find any corroboration from the evidence on record or support from the testimonies of other witnesses. This witness claims to be roaming around freely in the area where throughout the day there was violence, ransacking and arson by Hindu mobs without being harmed, only because she was wearing a khaki uniform. The fact regarding her having put on a khaki uniform is also doubtful because whereas in her examination in chief, she has stated that she had put on her uniform to go to her workplace. In a cross-examination, it has been elicited that on the previous day, that is 27 February, they were told that in view of the call for Gujarat Bandh, they should not come on 28th, and hence, as rightly submitted by the learned counsel for the appellants, there was no reason for her to put on her uniform. It is the case of the witness that after Mayaben and her assistant got down from the car, Mayaben was talking with the people in the mob. Mayaben was standing near the masjid, and upon the people in the mob coming near, she gestured with her hands and showed the Muslim area, and that she had heard her telling the mob to destroy the masjid and Muslim area. According to the witness, as she was wearing a khaki sari and blouse, she was not identified as Muslim and was taken to be a policewoman, and hence she, that is Mayaben, spoke in her presence. Thereafter, the mob resorted to violence. She has also stated that she saw Mayaben firing from a pistol. Firstly, the fact regarding the witness being in a khaki dress is doubtful in view of the contradiction brought out in her cross-examination. Moreover, the witness has stated that she saw a truck full of gas cylinders being brought and cans of kerosene in the hands of the people in the mob, and upon these being brought to the notice of the police by her, they had told her that it was their holiday and that they, that is the Muslims, had to die today. It may be noted that on one hand, the witness says that she being in a khaki uniform, people thought she was a policewoman, and on the other hand, she says that the police had told her that they had to die today, which clearly belies the version given by the witness regarding her being in a khaki dress. Thus, the testimony of the witness is self-contradictory. The entire story that she could stand alone close to Mayaben because she was wearing a khaki dress, therefore does not appear to be credible. The witness has stated that she has seen the whole family of the watchman of Mahavir Hall, in all 4 persons being done to death by the mob and cut into pieces and thrown on the road. However, there is no evidence to corroborate her say. From the evidence coming on record, there is nothing to suggest that any person was killed on the national highway in the Norolapatia area on the day of the incident. All incidents of killing are stated to have taken place inside the chawls, except in case of Abid, where some witnesses say that he died due to bullet wound in police firing and was burned by the mob. The witness also claims to have witnessed the killing of Varmaji Panwala. She also claims to have seen the mob looting her house. She further claims that Bipin Bhai Autowala had climbed on his shop and was firing from there. Apart from the fact that this version does not find corroboration from any other witness, it is difficult to believe that Bipin would fire from the terrace of Bipin Auto, in as much as from the testimonies of the witnesses it emerges that there were mobs of Hindus on both sides of the national highway, in which case it would be Hindus who would be injured in such firing. Her version of having made telephone calls to the police also does not inspire confidence. The witness also claims to have gone to Jawahar Nagar and having seen in the houses that were looted, there were ornaments and money which the SRP Jawans were putting in their pockets. She further claims, etc. I'll just not read that. And then 56.57 also on facts. Now kindly see the final analysis in paragraph 56.58. The witness, therefore, appears to have come up with a highly exaggerated version of the incident, and that too for the first time after 6 years. Considering the overall testimony of this witness, she does not come across as a truthful and credible witness. Her entire testimony does not inspire any confidence, and therefore no part of her testimony can be relied upon to convict the accused named. એટલે સેકન્ડ સેટ, એક સેટ પોલીસ સ્ટેટમેન્ટ આપ્યા, નામ નથી અને ફર્સ્ટ ટાઈમ આપે છે એસઆઈટી માં, અથવા તો પોલીસ સ્ટેટમેન્ટ છે જ નહીં અને ફર્સ્ટ ટાઈમ દે કમ ફોરવર્ડ ટુ ગીવ ધ સ્ટેટમેન્ટ બિફોર ધી એસઆઈટી. બોથ ધ સેટ ઓફ વિટનેસીસ આર નોટ બિલીવ્ડ બાય ધી ડિવિઝન બેન્ચ. સાહેબ, મારા કેસની અંદર 6 વિટનેસ એવા છે કે જેમને પોલીસ સ્ટેટમેન્ટ આપ્યા છે પણ મારું નામ નથી, અને પહેલી વખત સીધા 6 વર્ષ પછી મારું નામ આપે છે. અને 6 વિટનેસ એવા છે કે જેમના પોલીસ સ્ટેટમેન્ટ નથી, ફોર ધ ફર્સ્ટ ટાઈમ મારું નામ એસઆઈટી માં 6 વર્ષ પછી સ્ટ્રેટ વે આપે છે. એન્ડ ધેટ ટુ attributing the role at the same point of time where my presence is somewhere else. એ જ સમયે પાછી નરોડા પાટિયા મારી હાજરી બતાવી છે, which is disbelieved by the court. हाँ, 56.57. I am thankful to my learned colleague. સાહેબ, આખા કેસની અંદર ત્યાં અને અહીંયા I am the only lady accused. All other male members are there. Therefore, when I am identified by somebody, when a witness says ke Maya Ben, naturally only one lady is there in the dock, and therefore it is very easy to identify. એટલે સાહેબ, મારું identification by a witness also does not merit as a matter of fact. એટલે સાહેબ 56.57 માં આ વસ્તુ હાઈકોર્ટે પણ કહી છે. Kindly see. This witness has named accused 37 Mayaben, her assistant, accused number 44 Bipin, Guddu, and 22 Suresh. Out of the accused named by her, she has identified accused 37. She has identified accused number 44 Bipin, but has stated that she cannot remember his name at present. She has thereafter identified accused number 38 as Mayaben's assistant and has not identified 22. Thus, the witness could not identify 62 and 22 and has identified 44 by his face and not by his name. Thus, the only accused whom she has fully identified is Mayaben, who, being a public figure, her photographs and posters would be easily accessible. Moreover, in this case, there is no other female accused of her age, and therefore, it is very easy for anyone to identify her. એટલે પ્રોસિક્યુશન સાહેબ જો કોઈ વિટનેસ એમ કહેતું હોય કે ભાઈ એને આઈડેન્ટિફાઈ કર્યા છે, that may be considered as one of the circumstances, that also should not be given that weightage in our humble submission in view of the this finding by the division bench. And I said last principle which the honorable court will find in the last volume, volume number 10.
Yeah.
સેમ વોલ્યુમ સાહેબ, મેં જે આગળ સૌથી પહેલા જે મેં કોન્સ્પિરસી માટે વાંચ્યું ને 3 પેરેગ્રાફ વાંચ્યા, એ જ વોલ્યુમ.
Volume 1, 10. Page number.
Page 3213. Paragraph 466. સાહેબ પેલી જે 2 witness or 3 witness or 4 witness theory, when there are large number of accused and large number of witnesses, Supreme Court in Nashalti's case, right from 1965, thereafter it was followed in various other cases. કોઈ જગ્યાએ સુપ્રીમ કોર્ટે 2 witness theory માની છે, કોઈ જગ્યાએ 3 witness theory માની છે, એક કેસની અંદર 4 witness theory માની છે. અહીંયા of course accused side would definitely say that maximum number of witnesses theory may be applied. But in Narora Patia case, the Honorable High Court has applied 2 witnesses theory, and the logic which is applied in that case has been stated here in 466. The next question that arises for consideration is whether or not to adopt the 2 or 3 witnesses theory propounded by the Supreme Court in case where the court has to deal with evidence pertaining to the commission of an offense involving a large number of offenders and a large number of victims, by adopting the test that the conviction be sustained only if it is supported by 2 or 3 or more witnesses who give a consistent account of the incident. Reference may be made at this stage to the relevant findings of the trial court while rejecting the request of the defense to adopt the 2 or 3 witnesses theory which are extracted below. સાહેબ નીચેની કોર્ટે જે ફાઇન્ડિંગ આપ્યું એ છે. It is useful to draw a picture of the situation on that day. On 28/2, it was a situation of total subversion and erosion of rule of law at Naroda Patia right from about 9:30 a.m. or so to evening at least up to 8:30 p.m. With the highest respect, it needs to be stated that it is true that in Mashalti's case, Dancing's case, etc., the fact situation was not like the case on hand. There were no frequent change in the investigating agency. There was no allegation that the investigating agency was held a particular community against the another community. That case did not come for its trial after 7 years. There was no transfer petition filed in that case before the Honorable Supreme Court, and in that case, no need was noticed to constitute special investigating team on the ground that previous investigation was improper, and even there was no order for further investigation, which all had happened in this case. A very notable fact of this case is, since the trial has commenced after 7 years or so, and many prosecution witnesses had opportunity to testify after 8 years, several prosecution witnesses have died on account of the negative impact of the incidents, that is the communal riots. Many of the witnesses, many of the victims who were nowhere heard and who have even left the city of Ahmedabad with the silence that they have adopted, and thus the situation as is prevalent in routine communal riot cases is not existing in this case, that after this spur of the moment things get settled itself. Most importantly, because of dropping, death, unavailability, migration of the eyewitnesses for some of the accused, in fact, no prosecution witness was available, though was available at the stage of investigation, and for some of the accused now none is available, and for some of the accused only 1 or 2 prosecution witnesses are now available. In these circumstances, it is not prudent and proper to practice the need of 2 prosecution witnesses to involve the accused, as at times even 2 or also not available to depose, though in fact there were many witnesses. Hence, it would be in accordance with the discussed citations, principles of appreciation of evidence, principle of justice, equity and propriety to practice the theory of need to one reliable prosecution witness to bring home guilt of the accused. Not adopting the policy would cause serious prejudice to the victims, and it is also essential to strike the balance. The benefit of examining many star eyewitnesses is now not available to the court. Hence, for the occurrence, even if in 2002 there were many eyewitnesses, today hardly 1 or maybe 2 are available who have been examined as prosecution witness. And even some of them have been dropped by the prosecution to avoid repetition. Considering the above situation, a theory of 2 prosecution witnesses practiced, it is likely to cause serious prejudice to the prosecution and victims. After 8 years, it is already difficult for the prosecution to find out the victim, and then after, if such a theory is practiced, it would be amounting to adding injustice to the victims of riot. The usual theory of expecting at least 1 reliable prosecution witness is not going to cause any injustice to the accused, and it would be very just and proper in the facts of the case. To put a rough estimate, it may be mentioned that as the record reveals, about 29 witnesses had died before the matter had reached its trial. 18 witnesses were not found in spite of diligent efforts. Since these witnesses were not examined on account of the death, and they being not found. It is very typical circumstance. The court did not have benefit of their first-hand experience and version from personal knowledge, which needs consideration as even after this loss of witnesses to the prosecution, the theory of need of 2, 3, or 4 witnesses, if would be practiced, then that would be prejudicing the interest of prosecution and of victim, and ultimately of justice, which cannot be permitted. 263 was summoned to produce the record of London Metropolitan Magistrate Court, wherein numerous C summaries were filed by the crime branch, which were filed during the tenure of the then I.O. Chudasama. These C summaries were filed for many of the complaints. Along with the material, certain statements, certain Xerox and original printed complaints application, and damage analysis forms were tagged. C summaries were filed on the ground that the complaint has been lodged by the mistake of fact. This was perhaps with reference to the fact that many complaints have been merged in CR number 100 and others. About 24 RNP and C summaries have been summoned up, which all have been exhibited as exhibit so and so. Some of such C summaries are worth discussing to know the kind of insufficient investigation done to highlight that this is a fit case to adopt the practice of sufficiency of one reliable prosecution witness to bring home the guilt. The strong circumstances pointing to the involvement of the accused right from the year 2002 in the serious offenses committed in the riot, including the murders, slitting stomach of a pregnant woman, etc., gets confirmed even though this record. Now kindly see the High Court's finding. With due respect to the findings recorded by the trial court, in the opinion of this court, the delay in the trial and change in investigation cannot be attributed to the accused, inasmuch as it is not on account of any act on the part of the accused that the delay has occurred. Besides, it is for the prosecution to prove its case beyond reasonable doubt, and settled principles of law cannot be brushed aside on the ground that though witnesses were available at the relevant time, they are not available now. The record of the case reveals that in all 327 witnesses have been examined by the prosecution, several witnesses who have not named any accused nor stated anything which could further the prosecution case have been examined by the prosecution, and several witnesses who had named the accused have been dropped. At the stage of trial, the trial court could have rejected the application for dropping of witnesses if it thought that such witnesses are important witnesses. Thus, when the prosecution deliberately drops witnesses whose testimonies may have supported its case and examines witnesses whose testimonies no manner furthers its case, the accused cannot be put to a disadvantage and be deprived of the benefit of the legal principles established by the Supreme Court. Moreover, from the nature of the evidence which has come on record, wherein in some cases the court has found a witness to be credible, subject to corroboration by some other witness, this court is of the view, kindly see, this is the principle. This court is of the view that it would not be proper to convict an accused on the basis of a testimony of a single eyewitness. However, considering the manner in which the incident has occurred, as well as considering the fact that the faces in the mob are seldom known faces, the court is of the view that the interests of justice would be subserved if the two witnesses test is adopted. Now, let's pausing here for a moment. In this case, the case is slightly different than the case of Narora Patia. In Narora Patia, what happened? That in a chawl inside, large number of persons have been burnt alive, and the total toll of the death was 97. Here, nothing of the sort has happened. And therefore, here the toll perhaps is 11. Not that big as that of Narora Patia. Of course, this toll of 11 death is also a big as such, but not in comparison to Narora Patia. And therefore the court, because there the faces were not known. Here in this case, as far as the accused persons are concerned, those accused persons are residing in the same area. They are known to all witnesses. And therefore it is very easy to implicate anyone who is known to a witness and who wanted to implicate somebody. Therefore, though in this case, Narora Patia case, two witness theory is adopted. One witness theory is already not considered by the trial court, but the High Court said that no, that criteria adopted by the trial court is not proper. At least two witness theory has to be applied. In my humble submission, here is a case where minimum 3 to 4 witnesses theory, at least we request on the defense side to apply. with a view to see that no innocent person, only on the basis of one or two witnesses, be convicted. Therefore, more witness theory may kindly be applied. That is a request on behalf of the defense I am making. Now, the court said, as far as the application of that theory is concerned, 469. The next question that arises for consideration is how to apply the two witnesses test. As discussed here in above, the incidents took place throughout the day. હા સાહેબ, આ રીતે જુદું પડે છે. ત્યાં સવારના બી ઇન્સિડન્ટ થયા, બપોરના બી થયા, સાંજના થયા, અલગ અલગ જગ્યાએ થયા, ચોલની અંદર થયા. એવો કેસ નરોડા ગામમાં નથી. Because the time of the incident which is indicative is between 12 to 2. Here, as discussed herein above, the incidents took place throughout the day, and the witnesses have seen the accused at different parts of the day indulging in different offences at different spots in the area, namely Nurani Masjid and the areas nearby, as well as on the road in front of the Nurani Masjid and ST workshop, and the chawl situated on the side of the road beside the ST workshop compound wall till the end of the road, that is Gopinath Society. Therefore, should the court insist upon two witnesses who have named and accused in connection with the same incident, or two witnesses who have named and accused in any incident that took place throughout the day? In the opinion of this court, considering the evidence which has come on record, as several incidents have taken place throughout the day, it is quite natural that there may not be two eyewitnesses available in respect of each individual incident. Consequently, it would not be proper to insist upon two witnesses testifying regarding the same incident. Therefore, if any two witnesses name and testify against a particular accused in any incident throughout the day, that should be considered as sufficient evidence against such accused, provided, of course, that the court has found such witness to be a credible witness, has accepted her testimony on its own stand. So this is about the multiple witnesses theory and the finding. And the last paragraph, as far as 149 is concerned, the very next paragraph, 470. After conducting such exercise, the next question which would be required to be addressed is when the accused who meet with the two witnesses test are identified, in what manner would section 149 of the IPC operate for each such accused? In other words, the question that arises for consideration is, if the presence of the accused has been established only in the mob on the road in the morning or afternoon hours, where no offense against the human body has been found to have taken place, whether such accused can be held guilty for the commission of the offense under sections 323, 325, 326, 302, 307, 440, read with section 149 of the Indian. Now, the final conclusion in this regard is in after the law is discussed in para 472. This is the last paragraph, which I'll be reading from the judgment of Naroda Patia. 472, page 3224. In the facts of the present case, as is evident from the evidence that has come on record, mobs comprised of thousands of people gathered on the length and breadth of the road in front of the Nurani Masjid and ST workshop, from Natraj Hotel to SRP Quarter Gate and beyond. This mob indulged in heavy stone throwing and damaging and destroying properties and setting them ablaze, as well as damaging and setting the Nurani Masjid on fire. While witnesses have attributed weapons in the hands of several accused, no overt act has been alleged by using such weapons. Therefore, insofar as the mob on the road is concerned, there is no allegation of any offense affecting the human body, thereby attracting the provision of section 323, 325, 326, 302, 307, read with section 149. Some of the accused named by the witnesses have been seen only in the mob on the road in the morning, whereas the police witnesses have referred to the presence of some of the accused in the afternoon at around 2 to 3 p.m. However, except to the extent noted earlier, no allegation of any physical violence against any person has been alleged. Therefore, insofar as the common object of the unlawful assembly, which was on the road, is concerned, it appears that it was to damage and destroy the properties of the Muslims and to damage and destroy the religious place, the Nurani Masjid. In the opinion of this court, the people who formed part of the unlawful assembly on the road in the morning or afternoon can be presumed to share the common object to the extent referred to herein above. There is no evidence on record except in the case of the accused who have been found guilty of the offense of criminal conspiracy under section 120B of the IPC, that they knew that the offenses which were committed by the unlawful assembly inside the chauls and in the passage of Gangotri and Gopinath society, and thereby areas were likely to be committed. Therefore, insofar as the acts committed by the individual by the unlawful assembly or at different times of the day are concerned, those persons in the unlawful assembly who had left the assembly or were not part of the unlawful assembly subsequently cannot be held guilty of the offense committed inside the chauls and the societies on the rear side of the chauls. As held by the Supreme Court in the decisions cited herein above, a court is not entitled to presume that any and every person who is proved to have been present near a riotous mob at any time or to have joined or left at any stage during its activities is in law guilty of every act committed by it from the beginning to the end, or that each member of such a crowd must from the beginning have anticipated and contemplated the nature of the illegal activities in which the assembly would subsequently indulge. In other words, it must be proved in each case that the person concerned was not only a member of the unlawful assembly at some stage, but at all the crucial stages had and shared the common object of the assembly at all those stages. The complicity of the accused in a particular offense shall therefore be required to be decided on the basis of the presence of such accused at a particular stage. So this is on applicability of 149. So this is virtually the completion of the factual submissions and the submissions on the basis of the judgment of Dhanura Bhatia. Now, as far as the reference to law, we have given 44 judgments. સાહેબ એનું એક ખાલી ઇન્ડેક્સ ઉપરનું આપ જોશો તો હું એમાં એક સેમ્પલ જજમેન્ટ ખાલી બતાવી દઉં કારણ કે પ્રિન્સિપલ અધરવાઇઝ ઇઝ ધ સેમ. એનું ખાલી ઇન્ડેક્સ છે ને 3-4 પેજનું આપણે સાથે જોઈએ. અને મોસ્ટ ઓફ ધીસ જજમેન્ટ્સ were relied in Naroda Bhatia case and they are referred to by the honorable court in the judgment. Therefore, ક્યાંક ને ક્યાંક સાહેબ એનો રેફરન્સ છે જજમેન્ટમાં આવી જ જશે. સાહેબ delayed statement ઉપર there are about 10 judgments we are citing. પણ આમાં સાહેબ બહુ મારે ઊંડા એટલા માટે ઉતરવું નહીં પડે કે that principle is already decided by the division bench in the same set of facts. એટલે કોર્ટે કહ્યું કે delayed statement છે, SIT નું જે ડિલે છે એમાં તો પ્રોપર એક્સપ્લેનેશન આવવું જોઈએ છે, કોઈનું નથી આવતું. As far as police statements are concerned, which are though little belatedly recorded after 2-3 months, but the division bench said that in a given case where there was a turmoil in the city and so many persons have died, the victims were in a particular mental condition, so that delay was not considered as fatal. So police statements were also relied, but as far as the seat is concerned, there the honorable court expected the witness to explain as to why there was a delay. Now that explanation was not rendered by the witnesses, and therefore this part is already considered by the division bench. As far as conspiracy is concerned, there are number of judgments on the conspiracy, and conspiracy section decided by the division bench is also read by the honorable court in detail, as the honorable court indicating that the court had already called for that particular section. Because in Naroda Bhatia, except 3 persons, conspiracy is not believed, which I have read. Here also, perhaps the factual scenario is better in this case, Naroda Gam case. Therefore, the question of conspiracy and invocation of section 120B by the prosecution in our humble submission should not be believed, because there is no direct, indirect or circumstantial evidence found that the accused persons were in concert with each other. There was already a pre-meeting of mind among them to commit a particular crime. And the division bench in Naroda Bhatia has already said that it was spontaneous. because of the earlier incident which had taken place at Godhra the earlier day. The people had spontaneously come out and had started ransacking and damaging the property and beating the people. Therefore, the conspiracy part, which was already discussed by the division bench, the same would apply. And similar is the position about the 149, which is the third head. Now, as far as the riot, as far as the witness theory is concerned, we are relying upon 6 judgments. If the Honorable Courts, I may just read the particular, rather the ratio of the judgment. Like Mashalti, I have already read from that Narora Patia. Then there is another judgment in 1997 Supreme Court in Binay Kumar's case. The court said that law pertaining to 2 and 3 witness rule reiterated and followed. Now, in that case, the court had bifurcated on the facts. For some of the accused, the court had applied 2 witness theory. For some of the accused, the court had applied 3 witnesses theory and had given the reasons as to why the court is doing so. Then third judgment is 2001 Supreme Court, Chandrasekhar. In case of involvement of large number of accused persons, prudent to adopt 2 witness theory. Then 97 Supreme Court, State of UP, Dancing. In facts of the case, due to involvement of large number of accused persons, prudent to adopt 4 witness theory. So there are 4 reliable witnesses if are deposing against 1 accused, then only that witness has to be believed. That is what is stated. Then Kailash Gore, 2012 2 SCC. The rules of evidence and the standards by which the same has to be evaluated also cannot be different in cases depending upon whether the case has any communal overtones or in an ordinary crime for passion, gain or avarice. સાહેબ એમાં એક પેરેગ્રાફ આપ પરમિટ કરો તો હું વાંચું પેજ 1067 અને 1068 ઉપર, which would be in 3rd volume. ત્રીજું વોલ્યુમ પેજ નંબર 933 થી શરૂ થાય છે. Internal page 14 on 1067, paragraph 43. At any rate, the legal proposition formulated by Bedije based on the past failures. 42. On the past failures do not appear to us to be the solution to the problem. We say with utmost respect to the erudition of our brother that we do not share this view that the reports of the Commission of Inquiry set up in the past can justify a departure from the rules of evidence or the fundamental tenets of the criminal justice system. That an accused is presumed to be innocent till he is proved guilty beyond a reasonable doubt is a principle that cannot be sacrificed on the altar of inefficiency, inadequacy, or inept handling of the investigation by the police. The benefit arising from any such faulty investigation ought to go to the accused and not to the prosecution. So also, the quality and credibility of the evidence required to bring home the guilt of the accused cannot be different in cases where the investigation is satisfactory vis-a-vis cases in which it is not. The rules of evidence and the standards by which the same has to be evaluated also cannot be different in cases depending upon whether the case has any communal overtones or in an ordinary crime for passion, gain or avarice. The prosecution, it is axiomatic, must establish its case against the accused by leading evidence that is accepted by the standards that are known to the criminal jurisprudence, regardless whether the crime is committed in the course of communal disturbances or otherwise. In short, there can only be one set of rules and standards when it comes to trials and judgment in criminal cases unless the statute provides for anything specially applicable to a particular case or class of cases. Beyond that, we do not consider it necessary or proper to say it. એટલે આટલું બધું ડેમેજ થયું છે કે 11 જણા ગુજરી ગયા છે. Sentiments have no place. Ultimately, the standard of proof which is required to be led by the prosecution is the same in an ordinary crime and a crime which is done by the people, large number of people who can be said to be communal frenzy, and ultimately a serious crime is committed. અને સાહેબ આ જે દિલાવર હુસેનનો કેસ છે ને એમાં પણ બહુ જ સુપ્રીમ કોર્ટે very beautifully it has narrated, but which I have already read when on the first day when I have read the judgment of Narora Patia. There that is reproduced and I have already read. There it is said that credibility of witness has to be measured by the same yardstick, even in cases arising out of the communal frenzy. And I first principle તો એવું કહ્યું છે કે sentiments or emotions, however strong, are neither relevant nor have any place in the court of law. પછી સાહેબ ઓમ્નિબસ એવિડન્સ અને અનરિલાયબલ એવિડન્સ ઉપરના આ બધા જ જજમેન્ટ છે. પ્રિન્સિપલ બધામાં લગભગ સેમ છે. સાહેબ સેમ્પલ માટે એક 2-3 જજમેન્ટ આપ સાહેબને વાંચું. એક સાહેબ 1974 સિરિયલ નંબર 5 ઉપરનું છે ને, only one paragraph is there. Harchand Singh versus State of Haryana. It is at page 1126. I request the Honorable Court to read 1129. Paragraph 10. Only one paragraph I'll read. The other eyewitness upon whose testimony reliance has been placed by the prosecution is Ram Asar, PW 14. So far as this witness is concerned, we find that his presence at the scene of occurrence was not mentioned by so and so deceased in the dying declaration, which was recorded by the ASI so and so. According to Ram Asar, he was working with the deceased at the well when the 3 accused came there and assaulted the deceased. If Ram Asar was in fact present and working with so and so deceased at the time of occurrence, it is not clear as to why the deceased should fail to mention that fact in the dying declaration. The evidence of so and so, so and so, and so and so, upon which also the prosecution placed reliance, goes to show that Ram Asar had not witnessed the occurrence. Name of Ram Asar was in the very nature of things not mentioned in the first information report, because the said report was based upon the dying declaration of so and so. Now kindly see these 5-6 lines. It would thus appear that the eyewitness upon whose testimony the prosecution wants to sustain the conviction of the appellants is shown to be an unreliable witness by the other evidence produced by the prosecution. The present is a case wherein one set of prosecution evidence condemns the other set of evidence produced by the prosecution. The present case is, that line is repeated, sorry, in the printing. In the above set of affairs, we find it difficult to secure a firm ground upon which to base the conviction of the accused appellant. Sahib, અહીંયા one set of evidence which is produced by the prosecution shows my presence at Sola. Another set of prosecution evidence in form of the witnesses who have come forward for the first time after 6 years, that they are saying for showing my presence at Narodagam. Now, if there are 2 sets of evidence which is produced by the prosecution itself, which is enough to destroy, one is enough to destroy the other. Therefore, this principle, it is applied as far as A57 is concerned. There would be no case. That all judgments and the paragraphs which we indicated, if they are read, of course, on the same, and then serial number 10 also may kindly be seen, Kaliram. I'll just read out the points. Burden is upon the prosecution to prove different ingredients of the offense. If two views are possible, benefit ought to go to the accused. Concept of benefit of doubt, and consequences of innocent convicts are far more serious. If the Honorable Court kindly see page 1173. Sir, para 22, exactly somewhere in the middle. The burden of proving the guilt of the accused is upon the prosecution, and unless it relieves itself of that burden, the courts cannot record a finding of the guilt of the accused. There are certain cases in which statutory presumptions arise regarding the guilt of the accused, but the burden even in those cases is upon the prosecution to prove the existence of facts which have to be present before the presumption can be drawn. Once those facts are shown by the prosecution to exist, the court can raise the statutory presumption, and it would, in such an event, be for the accused to rebut the presumption. The onus, even in such cases, upon the accused is not as heavy as is normally upon the prosecution to prove the guilt of the accused. If some material is brought on the record consistent with the innocence of the accused, which may reasonably be true, even though it is not positively proved to be true, the accused would be entitled to acquittal. Then, paragraph 25. Another golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted. This principle has a special relevance in cases wherein the guilt of the accused is sought to be established by circumstantial evidence. Rule has accordingly been laid down that unless the evidence adduced in the case is consistent only with the hypothesis of the guilt of the accused and is inconsistent with that of his innocence, the court should refrain from recording a finding of guilt of the accused. It is also an accepted rule that in case the court entertains reasonable doubt regarding the guilt of the accused must have the benefit of that doubt. Of course, the doubt regarding the guilt of the accused should be reasonable. It is not the doubt of the mind which is either so vacillating that it is incapable of reaching a firm conclusion, or so timid that it is hesitant and afraid to take things to their natural consequences. The rule regarding the benefit of doubt also does not warrant acquittal of the accused by report to surmises, conjectures, or fanciful criminal trial, fanciful consideration. As mentioned by us recently in the case of State of Punjab versus Jagir Singh, a criminal trial is not like a fairy tale wherein one is free to give fight to one's imagination and fantasy. It concerns itself with the question as to whether the accused arraigned at the trial is guilty of the offense with which he is charged. Crime is an event in real life and is the product of interplay of different human emotions. In arriving at the conclusion about the guilt of the accused charged with the commission of the crime, kindly see this now, the court has to judge the evidence by the yardstick of probabilities, its intrinsic worth, and the animus of witnesses. Every case in the final analysis would have to depend upon its own facts. Although the benefit of every reasonable doubt should go to the accused, the court should not at the same time reject the evidence which is ex facie trustworthy on the grounds which are fanciful or in the nature of conjectures. Then kindly see paragraph 26. Two more paragraphs I'll read. It needs all the same to be re-emphasized that if a reasonable doubt arises regarding the guilt of the accused, the benefit of that cannot be withheld from the accused. The courts would not be justified in withholding the benefit because the acquittal might have an impact upon the law and order situation to create adverse reaction in the society or among those members of the society who believe the accused to be guilty. The guilt of the accused has to be adjudged not by the fact that a vast number of people believe him to be guilty, but whether his guilt has been established by the evidence brought on record. Indeed, the courts have hardly any other yardstick or material to adjudge the guilt of the person arraigned as accused. Reference is sometimes made to the clash of public interest and that of the individual accused. The conflict in this respect, in our opinion, is more apparent than real. As observed on page 3 of the book entitled The Accused, so and so edition. When once it is realized, however, that the public interest is limited to the conviction, not of the guilty, but of those proved guilty, so that the function of the prosecutor is limited to securing the conviction only of those who can legitimately be proved guilty. The clash of interest is seen to operate only within a very narrow limit, namely, where the evidence is such that the guilt of the accused should be established. In the case of an accused who is innocent or whose guilt cannot be proved, the public interest and the interest of the accused alike require an acquittal. In the last principle, it is no doubt true in para 27 that wrongful acquittals are undesirable and shake the confidence of the people in the judicial system. Much worse, however, is the wrongful conviction of an innocent person. The consequences of the conviction of an innocent person are far more serious, and its reverberations cannot be but be felt in a civilized society. Suppose an innocent person is convicted of the offense of murder and is hanged. Nothing further can undo the mischief for the wrong resulting from the unmerited conviction is irretrievable. To take another instance, if an innocent person is sent to jail and undergoes the sentence, the scars left by the miscarriage of justice cannot be erased by any subsequent act of expiation. Not many persons undergoing the pangs of wrongful conviction are fortunate like so and so, so and so. You know, there something is quoted, Maloch, which is difficult to understand. So I'll not read. Other judgments are on the same line. And the last section is about the defense witnesses. Now, only one judgment I may read as a sample. (1205). The other judgments also are on the same line. 1208, paragraph 3 may kindly be seen. 1208, para 3. Without attributing any motive and taking the evidence on its face value, therefore, it appears that the place of occurrence was at 400 to 500 yards from the place of Panchayat. And it is on this piece of evidence the learned advocate for the state heavily relied upon and contended that the distance was too short, so as to be an impossibility for the accused to be at the place of occurrence. We cannot but lend a concurrence to such a submission. A distance of 400 to 500 yards cannot be possible to be said to be presence elsewhere. It is not an impossibility to be at the place of occurrence and also at the Panchayat meet. The distance being as noticed above, the evidence on record itself negates the plea, and we are thus unable to record our concurrence as regards acceptance of the plea of alibi as raised in the appeal. Before drawing this curtain on this score, however, we wish to clarify, this is a low later. We wish to clarify that the evidence tendered by the defense witnesses cannot always be termed to be a tainted one by reason of the factum of the witnesses being examined by the defense. The defense witnesses are entitled to equal respect and treatment as that of the prosecution. The issue of credibility and the trustworthiness ought also to be attributed to the defense witnesses at par with that of the prosecution. A lapse on the part of the defense witness cannot be differentiated and be treated differently than that of the prosecution's witnesses. So here, as far as the accused is concerned, that is A57, we have examined 10 defense witnesses, and all of them, except the taking bare denial, nothing further has been elicited by the cross-examination done by the prosecution. Therefore, those witnesses should be at par, should be placed at par. In two of the defense witnesses I have read, where they themselves suggest કે આ તમે આને આટલા વાગે ત્યાં જોયા હતા, એનું ડિનાયલ લેતી વખતે પણ. Therefore, it is their own case કે ભાઈ આ ત્યાં એમની હાજરી છે 11 વાગે 11:30. How can she be present at Naroda Gam at the very point of time? And as we have already submitted that the call details and call records very specifically indicate her presence there at somewhere else than the places which are mentioned by the witnesses. So, big question, we were just discussing outside the court, and I may just clarify the court that as far as Naroda Patia case is concerned and the findings given by the division bench of the High Court are still at large because the judgment is challenged. That is what perhaps might be submitted by the prosecution. But I may just clarify that that challenge is only by those accused whose conviction is confirmed. Those accused whose conviction is set aside. Some 19 accused persons are acquitted by the High Court. That acquittal is not challenged either by the state or by the SIT. And even by the victims also. Therefore, in my submission, those findings, qua the accused who are acquitted, has attained finality. So it would not now it would not lie in the mouth of the prosecution that these findings in Naroda Patia case is not final and still are at large before the Honorable Supreme Court where there is some challenge. But the challenge is by the accused. And even otherwise, the law on the point is very clear. There are two Supreme Court judgments. If necessary, we'll give a copy. That the law of the land once is prevailing, that would apply to any case which is pending, unless set aside or stayed by the higher. So today, in Naroda Patia case, the law is already declared. Principle of application of witnesses theory is already there. Now that is the land of the law, law of the land by a precedent. Now that is not challenged, that is not set aside, no stay is granted. One principle I'm saying, on all principles, whatever principles which are decided by the division bench, they prevail today. It is the law of the land by way of precedent. And therefore, perhaps prosecution would not be able to say that since it is still under challenge, it cannot be said to be final. It has already attained finality. That is what the submission is. I think nothing further is to be added. And with a very humble prayer, we request the Honorable Court to kindly acquit as far as A57 is concerned. And as far as the other accused persons are concerned, the law which is laid down by the Supreme Court in the copies we have supplied, that may be made applicable to them. We are very highly obliged for a very patient hearing.